In a matter of hours, people across the country will be heading to the polls. One of the biggest items on the ballot in Louisiana is the unanimous jury amendment. Voters will decide whether to do away with a law that's been around since the Jim Crow era. Chris Jackman spoke with law experts about what this could mean for future cases.
And it could be something big. This could be a game changer, Natalie, for the state of Louisiana. Now, if approved, Amendment 2 would put the state in line with the rest of the country when it comes to having a unanimous jury verdict for felony cases, something many of the legal community say is long overdue. Drive up and down the road and you'll likely see these signs asking you to vote yes for Amendment number 2. It's seeking to abolish a law that's been on the books since 1898. One William Snowden knows has a dark past. So tell us about the history of the non-unanimous jury law.
That was created to do two things. One, to nullify the black vote if, in fact, African Americans were able to get on the jury. Additionally, it would make it easier to convict African Americans with the idea that in the event that unanimity was not required.
Snowden is a member of the Unanimous Jury Coalition, a group of organizations that has spent this election year educating the public about the law.
This has been kind of this vestige of Jim Crow that has snuck under the radar for quite some time.
If Amendment 2 passes, all non-capital felony cases would require a unanimous vote by a jury. Since the state Senate passed a bill to allow voters to decide, it's received bipartisan support from both the left and the right. Are you surprised at all by all the bipartisan support?
I don't find it shocking for the mere fact that I think generally we as members in this community are familiar with this notion of unanimous juries. People are kind of taking this perspective of, what if I were that innocent person that we're going to trial?
Two recent high-profile cases had non-unanimous jury verdicts. One involved Cardell Hayes, the man convicted of killing Saints defensive end Will Smith. The other involved Ronald Gasser, the man found guilty of killing NFL player Joe McKnight. Both of the trials ended with 10-2 guilty verdicts.
Those both would have been hung juries, and the cases would have to have been tried again.
WWL-TV legal analyst Chick Foray.
I don't think anyone can argue with the fact that if you go from 10-2 for felonies in Louisiana, it's going to reduce the prison population, and it is indeed a form of prison reform.
Our partners at The Advocate found that 40% of the people who are convicted after jury trials in Louisiana, convicted by that, are non-unanimous juries. The only other state that has a similar law on the books to us right now is Oregon. So what does this mean for people who have already been convicted with non-unanimous jury verdicts? Well, Snowden says the way the law is written right now, it's not retroactive. Ton?
Carice, thank you.